It's 1:33. Welcome everyone to Will and Trust Seminar. I want to start this seminar off with the short prayer. So we'll invite Maria to do a short prayer real quick, Maria.
Sounds good. Thanks, Auntie. In the name of the Father, Son, and the Holy Spirit. Amen. Thank you, Jesus. Praise you, Jesus. Lord Jesus, we thank you and praise you for this time that you've given us to come together. Lord, we pray that you make these next 30 to 40 minutes fruitful. What you continue to use Tina Chichi as your instrument. We pray that you continue to guide each and every single one of us so that together we may continue to witness your love. Mom Mary, watch over us and protect us and guide us and guard us as we pray. Hail Mary, full of grace, the Lord is with thee. Blessed are you among all women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. In the name of the Father, Son, and the Holy Spirit. Amen.
Amen. Thank you, Maria. Welcome, everyone. Planning for the future is one of the most important steps I think we all need to take to protect our loved ones. So we have a very special guest. It's Tina Thomas. She's from Illinois. She's licensed attorney practicing in law and mainly in estate planning, real estate, and small business services and immigration. So please join us in inviting Tina. Tina, please take on it's yours, okay? Stay. If you need to
Great, thank you
share.
so much. Let me go ahead. And first of all, like Gigi said, my name is Tina. I am a attorney here in Illinois. Let me first start off, as attorneys like to do, we always give a disclaimer, right? So the kind of first thing that I want to just go off and say is that I am an attorney here in Illinois. So things are different state to state. And so I'm licensed here in Illinois, and I'm going to kind of go over some of the basic general concepts. Some of the examples that I will use will be, though, for Illinois based. So there are some things where it varies from state to state, and I'll try to point those out. When there are questions, I'm happy to answer them. If you want to type them in the box, and we'll try to, so that you don't forget them, we can try to, if I see them, go along with it, when I see them, to try and do it at that time. Let me go ahead and share my screen here so we can. You know what? We probably should have done this before, but I don't know if I have the permission to do that. But let me. Either way, I can share the document too afterwards. We
You should have access.
Okay, let's see. Okay, I think it's. Okay. Either way, we'll just keep going because I don't want to waste anybody's time. So, the main kind of question that everybody has is, first of all, not everybody knows what is estate planning, but then also, what is kind of the process? What happens if I don't have anything in place? So, we have kind of three tracks, if you will. The first is if it's a smaller estate. The second is if it's going to go through what we call probate, which I will explain. And then there's also what's called non-probate assets. So, really, first of all, what is estate planning? Estate planning is the process to arrange for the management and disposal of a person's estate, both during their life and after their death. So we want to make sure that There's four main goals and objectives for estate planning. First, that your assets are distributed according to your wishes. I'll try to mix in a little bit Malayalam too, so hopefully everybody can understand, but I just wanted to say that. So if there's any questions, uh, feel free to ask at any point, and we'll go through and answer questions at the end too. But yeah, so basically, first goal, നമ്മളുടെ ആസ്തിയെല്ലാം നമുക്ക് താല്പര്യമുള്ള പോലെ അത് വീതിക്കുക. That's the first goal. Second goal is you want to minimize taxes and legal fees. നമ്മളെ ഏറ്റവും ടാക്സ് കൊടുക്കുന്നതും ലീഗൽ ഫീസ് ഒക്കെ വരുന്നതും നമ്മളെ മാക്സിമൈസ് കുറയ്ക്കാൻ നോക്കുവാണ്. And then third one is if you have minor children, you want to account for what happens to them if, God forbid, something happens to you while they're still minors under the age of 18. So നമ്മുടെ 18 വയസ്സിന് താഴെയുള്ള പിള്ളേരുണ്ടെങ്കിൽ അവർക്ക് എന്ത് സംഭവിക്കും, അവരുടെ കാര്യങ്ങൾ ആരെയൊക്കെയാണ് ടേക്ക് കെയർ ചെയ്യേണ്ടതെന്ന് നമ്മളെ താല്പര്യം നമ്മൾ അറിയിക്കാൻ വേണ്ടിയും കൂടെയാണ് ഇത് ചെയ്യുന്നത്. So a lot of times people think, oh, I don't need to worry about writing a will or doing an estate plan until I'm much older. But really, sometimes when, God forbid, these things, tragedies happen, if the children are too young, that's really when they need the most protection, and you need to ensure that everything will go smoothly if something like that happened. And then the final objective and goal is to decide and say what happens to your healthcare and financial decisions in the situation where you're still alive, but there's some sort of incapacity. So either, your mental decline, no longer able to make those decisions, or some sort of hospitalization, coma, serious illness where you're still alive, but you cannot make the decisions properly. So those are all the kinds of things that we try to cover when we come up with an estate plan for you. A question people always ask about sometimes is taxes. So generally, currently, the federal tax threshold for estate taxes is $14 million, and that's for federal taxes. So it's about 14, it's like slightly under, like 13.99 million. So if your total assets is under that 14 million, you won't pay any federal tax, or your children won't have to pay any federal tax on the inheritance, or whoever your descendants' heirs are. It varies state by state. So it's for state taxes. So that can be different. Currently, the federal tax, it's a lot higher than it was. And this changes every year. So, every time there's new Congress, new president, a lot of times these things get changed. Right now it's at 14 million, but that law is set to sunset, which means it's supposed to change. It'll automatically revert back to a lower amount at the end of 2025, unless they do something again. So that number kind of changes, but it's a pretty high amount. So your average, middle class family, you're not going to have to deal with federal income taxes, but the state, like again, it varies state to state what the state taxes might be. So I just wanted to just talk about that right off the bat, just to cover that. So the next question people have, or sometimes the misunderstanding that people have, is they think, oh, ഒന്നും ഉണ്ടാക്കി വെച്ചില്ലെങ്കിൽ government എല്ലാം കൊണ്ടുപോകും. Like that's not true, actually. So even if you don't have anything in place, you never wrote a will, you never made a trust, you didn't do anything, your family will still get all of your assets. It's just a different process. It's longer, and it can cost more money. So those are the reasons you want to get something in place. But if you have family, your family will get it. So as long as if you have like no relatives whatsoever, then at that point the state could take it. But if you have living relatives and they're saying we are the ones that are ഇതിനുള്ള അവകാശികൾ ഞങ്ങളാന്ന് പറയാൻ relatives ഉണ്ടെങ്കിൽ അവർക്ക് അത് കിട്ടും. But still, like we said, we want to make sure that it's done properly so that it goes the best way possible. So I think I mentioned earlier, there's kind of three, I would say, classifications. If most states have something called like a small estate affidavit. That's what it's called here in Illinois. Might be different in different states, have a different name, but this is for people that their estate. First of all, I should say the word estate is what we use for um, everything somebody owns, their assets that are available to their family or their descendants when they pass away. That's called their estate. So for somebody with a small estate, there's usually most states have like a procedure to avoid the court process for a smaller amount. So in Illinois, that's called the small estate affidavit. And in Illinois, that threshold amount is $100,000 or less. So it has to be under $100,000, and it cannot include any real estate. So if you own real estate in Illinois, it won't qualify as a small estate. But if you don't have real estate and everything is under $100,000, it's like a more of a much simpler process. You fill out a form, you fill out who the legal heirs are, and then you kind of submit that. It's not like a long court procedure. So that's for people with a smaller estate. Um, if you don't qualify for that, then there's kind of two other tracks. The first being probate, and then the second being kind of avoiding the probate route. So probate is kind of the word for the court proceedings. So it's again can be called a little bit different things in different states, but typically it's like a probate case, or uh, we'll say you have to go to court and open a probate. So probate is it's like a court supervised process to validate a will if there is a will, and if there is no will, to distribute the assets. And so or to distribute the assets whether there is a will or there isn't. So even if there isn't, it goes through probate. Now, if you've created a proper estate plan to avoid probate, then you can avoid that process. So probate, it's not necessarily a bad thing, right? The main pro is that there is court supervision, so you can ensure that everything would be handled properly if that's a concern for you. But there are a lot of downsides to probate. The main two are the time and money. It's a long process. It can take 7, 8 months in most places at least, depending on the state and even on the county. It can take longer. So here in Illinois, for example, if you're in some of the suburban counties, it's a little bit quicker. But if you're in Cook County, where Chicago and a lot of the neighboring suburbs are, it can take like over a year. And depending on how complicated your family is, and or how complicated,
എത്ര പേരുള്ളതൊന്ന് പറയാവോ
uh,
എത്ര
depending on how
പേരുണ്ടെന്നോ
many,
അവിടുത്തെ നമ്പർ എത്രയാ മാറ്റി പിടിച്ചേ എന്തൊക്കെയാ അതാണ്ടോ
Tina, Tina, can you unmute yourself? Tina, we cannot hear you.
okay, can we hear
Yes,
better
there you
now? Okay,
Yeah.
okay, sorry, I must have accidentally hit mute. So depending on how long it takes, it kind of varies on a lot of things, just county to county, state by state. It can take longer just based on how the court is backlogged and the population of the county. That always kind of affects things. But it also depends a lot on how complicated your estate is. If you have a lot of businesses or different partnerships and things, that can complicate it if everything hasn't been set up correctly. And then different complications with each family. So for example, if you're dealing with a situation where maybe certain family members are fighting, they don't agree on certain things, or if there's different family structures where there were previous marriages or children from previous marriages versus newer marriages, all sorts of things. These are different things that can make things take a longer time. So the problem then becomes during that court process, what happens, right? If there's a business, if there's, assets that need to be taken care of, it can become challenging because a lot of the times, no one has the authority to handle all of that or take care of that or is willing to take care of that if they haven't received title to these properties yet or something. So you want to make sure to have that in place so that you can avoid those things happening and wasting time in that sense. Also, if something happens suddenly and let's, for example, say that your house is not, it was only in one spouse's name and it wasn't in the other spouse's name, then it becomes an issue of, if they need to do something, if a roof needs to be changed, does the spouse have the authority to do that when their husband or their wife passed away and the house is not in their name, and now you're dealing with all these issues but the estate is still being held up in court. These are the kinds of things that can happen, and so that's why we try to avoid probate when we do estate planning. The other kind of major downfall or negative is the cost. Estate planning, depending on your situation, it can be, it's a substantial cost to do the documents and get all that in place now, but almost most likely it will be much more costly for your family down the line if they have to go through the probate court process because for most people it'll require hiring an attorney. And like I said, it takes several months. So all those attorney fees and handling all of that, it's going to end up costing the family more money than it would have cost you to create the estate plan in most circumstances. So for that is another benefit of making an estate plan and making these documents before you pass away so that your family doesn't have to eat those costs later on down the line. Another big concern with probate versus non-probate is privacy. So when you go through probate, it's a public court process. Documents get filed. Your will be filed with the court. And like all court proceedings, unless there's some extenuating circumstances where the court would seal it or something, those are going to be public records. So anybody can go and pull up those records and see what your will was, see how much you had, see who is getting what. And most people, that's not something they would want, right? You want to keep those matters between you and your family. So if you have a trust or other estate planning and you avoid the probate process, you can keep that information private. And then finally, kind of one of the main reasons, of course, is you want to make sure that everything is distributed according to your wishes. And I'll explain that a little bit more down the line too. But, if you have nothing in place, every state has its own kind of formula for who gets what. So if you pass away and you have no will, no trust, you didn't make any estate planning documents, for example, here in Illinois, if you are married and you have children, your spouse will get half of it and your children will get the other half, split equally amongst the children. That's all of your children, both biological and adopted, legal children, not necessarily in-laws or stepchildren unless you adopted them. So half goes to the spouse and half goes to the child or the children, split equally. Again, this varies state to state. And then if you have only a spouse and no children, the spouse will get everything. If you have no spouse, but you have children, the children will get everything. If you don't have either, then it would go to your parents or to your siblings. Again, it varies state by state. Some states have different formulas for that. So in Illinois, parents each get a share and then siblings as well. Like I said, every state, that kind of stuff varies. So it depends. And this is, again, if you don't have any documents, who gets your property, your assets when you pass away. And even now, if you have these documents in place, for whatever reason, maybe you don't want everything split equally. Maybe you gave one of your children their share, so to speak, already, in advance, before you passed away. So you want everything remaining to go to the other child or children. So you might have different reasons, or for some specific reason, maybe you don't think that one child deserves to receive anything, or they deserve a smaller amount. Whatever the reason may be, according to your wishes, you want to make sure everything happens that way because it is your property and assets that you worked hard for. So, making the estate plan will allow you the best opportunity to do that. So, when we talk about the estate plan, what are the different documents? So we're gonna talk about that first. So first, I'm going to talk about the powers of attorney. So there's two types of powers of attorney. One for property or financial, your estate, and then one for healthcare. Now, powers of attorney, generally speaking, again, a lot of this stuff will vary. The details vary state to state. So you have to speak to an attorney in your state to get the specifics. So if you're in New York, California, Texas, Florida, it's not going to match up with exactly what it is in Illinois. But generally speaking, there's two types of powers of attorney. Sometimes they have different names. First one I'm going to talk about is regarding property, financial matters. Sometimes it's called a durable power of attorney. This is a document that is mostly in effect while you are still alive, but uncapacitated. So, for example, you have Alzheimer's or dementia. You're no longer able to make those important decisions for yourself in regards to your financial affairs. So, if you have, a house, or if you have, investments, retirement, pension, all of these things, depending on your medical situation at a certain point, you are no longer able to handle that properly. And so you want to make this power of attorney for property while you're still well and mentally 100% there to decide who is going to handle those matters for you if that happens to you. So a will, is for something that happens after you pass away. But sometimes there's that in between period, right? Unfortunately, we see it in our families all the time that, when people face certain illnesses and certain like maybe like a traumatic accident, whatever it might be, there become situations where people are still alive and they may live for several more years, right? A long time, but they're no longer able to take care of themselves or their assets. So you want to make sure that that's properly handled for, because a will is not going to cover that, because a will doesn't go into effect until you've passed away. So that's what a power of attorney for property is. It's designating what happens to your property and your assets while you are incapacitated but still living. And the main decisions you make in that power of attorney is who is going to be the person responsible. So you're designating one person to be the key decision maker and to handle all of those details when that power of attorney goes into effect. And how it goes into effect is, again, something that varies state by state, but typically you can put in there when it would take effect. And when I draft documents, the most often thing that we end up putting is when my doctor says I'm no longer able to handle my financial affairs, or a court has determined that I'm disabled and cannot handle those matters. So that's when that power of attorney would go into effect. And then it kind of can detail certain restrictions, certain things that you want to make sure that they do. Again, most states will have like a statutory format for a power of attorney for property. Illinois, for example, does. So it's a form basically that your attorney can go through with you and you can fill out and prepare so that you've named who it is. And now, for example, let's say you put your wife as your primary agent, your primary person to handle those matters, but they end up being unwell too, or they pass away already, or they're unable, or just, like can't handle it. You can, depending on the way the document is written, you can have other backup individuals. So if your spouse is no longer able, then one of your children or a sibling or whoever it is, you can have backups, and you can say, if this person is able, then I want this person. Otherwise, such and such person, like that. So that's the main reason you want to have the power of attorney for property. Similarly, you want to have a power of attorney for healthcare. And again, I keep saying this, but I just want to make it clear, it might be a little different in your state. There are different documents, and each state has different options when it comes to this as well. So the main one that we do here in Illinois is a power of attorney for healthcare. It's very similar to the power of attorney for property. Same situation. You're incapacitated but still living, no longer able to make your healthcare decisions and choices. That's when it would go into effect. So you're choosing the person that's going to be in charge of making those decisions for you. So if you are, hospitalized and the doctor doesn't feel like, there's a chance of recovery, what option do we want? Are we going to choose hospice? Are we going to keep them admitted? Do we want to try these treatments? Are we going to, if the patient codes, are they going to, intervene, do CPR, intubate, all of these decisions? Somebody has to make those choices if you're not able to make them. And so you're designating in a power of attorney for healthcare who it is that will make those choices, and speak with the doctors, and using the information that the doctors give them, make those decisions.
Tina,
In Illinois, you're not, typically you choose one person, and if they're not able, you have a backup, and a backup, we call them successor agents. And the reason for that is, if you say, I want all of my kids to decide, well, then what happens if they don't agree, right? You see that sometimes. Uh, Hopefully, you want your family all to talk and discuss it, and ideally they're going to be on the same page and make the decision together. But sometimes it just happens that way, right? Some person is, they just don't agree, right? One person thinks that this option is better. One person thinks, no, we should, try this, we should try that. And so ultimately, if there is no agreement, the person you choose will have the power to make the final decision. And so that's just to kind of avoid that fighting. It's one of the reasons that we want to have that in place. The other place is that the document itself will have different options as to for you to express some of your wishes and concerns in regards to that end of life care. You can say what kind of treatments you do or do not want, and perhaps like certain treatments that you would want to try. You want to receive pain medication. Would you want a feeding tube? These are all things you can think about. You don't necessarily have to address all of those things if you have a power of attorney. You can just simply say, like, this is the person that I want to make the decisions. And then they can make the best decision based on all the information at the time. Because as much as we can think about and plan for these things, there's no way of knowing, like, now what's going to happen down the line, right? When we're no longer able to make those decisions, we have no idea what the exact situation will be, what the medical circumstances are, what the options are. So there's no way really for you to consider every possible option and tell your family ahead of time what you would want in every single scenario. It just unfortunately doesn't work that way. And so you kind of have to choose somebody to make those decisions that you think will know best what it is that you would want. But there are other types of documents in each state. Sometimes it's called the living will or advanced directives. You can do them in conjunction with the power of attorney for healthcare. You can do them separately. It's not necessary to have every possible type of document, but it's again, vary state for state. So living will and advanced directives, they can get more specific into exactly what types of treatment that you do and do not want. That might be the better option for you if like if you have a specific illness and like for example, like Parkinson's or ALS or something like that, where you kind of have an idea of maybe what direction that's going to go in, or certain challenges that you'll probably end up facing as the disease progresses. So, depending on known circumstances, that might be a better route for you to specify more of into more detail what you would want. So that kind of covers kind of half of it, which is what happens when you're still living. And and also I will say these documents can also address what you would want to happen after you pass away as far as your body. So if you would want burial, or if perhaps you would want cremation, things like that, those are again varying state to state, things that you can include perhaps in your power of attorney for healthcare and advance directives. So, but generally speaking, the powers of attorney consider or deal with what happens to you before you pass away, while you're living but incapacitated. To deal with what happens afterwards, typically you will have wills and or trusts. So let me first talk about a will. A will is to, I think most people have a general idea, right? What happens to my assets, my property after I pass away? Who gets what? You make a will and you say, my house goes to so and so, my bank account goes to so and so. Or you can just say, all of my children, they each get, I have 3 children, they get 1/3 each. Whatever it is, you can split up each asset, you can split up everything equally or in certain percentages, however you would want it, you can split it up, and it will be specified in your will. But whether you have a will, or if you don't have any documents, even if you have the will, it still has to go through that probate process that we talked about before, which is through the courts. So if all you have is a will and you didn't make a trust, and you have more than that small estate that we talked about before. So let's say you have a property, maybe you have some money in the bank, and you have like a retirement plan that still has some money with it. So you have all of these things and you made a will. Your family will still have to take that will, go file it in court. They'll probably have to hire an attorney to go through the probate process in order to properly divide those assets and distribute them to your family members or to whoever you put in that will. And so for all those reasons that we talked about, the time, cost, privacy issues, typically speaking, when we do estate planning, we want to try and avoid probate. That is, for most people, one of the primary goals for creating an estate plan is to avoid that process. And so that is why we create a trust. Now, for the probably millionth time now, I'm going to tell you all these things that vary state to state. But there's different types of trusts. The most typical one, which is what I'm going to talk about, it's called a living trust or a revocable trust, meaning you can revoke it or amend it or change it. That's a trust that you create while you're living, and you can handle it and manage it while you're living. And then after you pass away, you designate in there who's going to handle it and who gets what. So again, it can be called a living trust or a revocable trust. Different states have some other names for it too, perhaps. So, but that's when most people are talking about a trust, that's what they're talking about. There are some other kinds of trusts, like irrevocable trust, meaning once you make it, it cannot be changed, it cannot be amended. Those are far more complicated, typically not something that the average middle class person is going to want or need. It's usually used in different scenarios where you're talking about like a great amount of wealth, or creating like different trusts, like charitable trusts, things like that. So for the average person, upper middle class, you're gonna make a revocable trust because while you're still living, you want to be able to change it depending on circumstances. Maybe you want to sell the property, maybe you want to downsize your house, maybe you want to move, things like that. You want to have the freedom and the ability to change those things because if you're doing this well in advance, then it might be several years before hopefully it's several years before you pass away, right? So you want to be able to change things accordingly as your life changes and you make different decisions. So when you make a living trust, if you are married and you share your assets, you can make it a joint trust with husband and wife, or you can do it individually. But typically, if it's husband and wife, if you do a joint trust, and while both are living, you're going to make it a trust where you both are the trustees and the current beneficiaries, right? So you own the property as so you make the trust doesn't have any property yet, right? And then once you create the trust, you have to transfer whatever property that you have into the name of the trust for it to be in the trust. So that's kind of like a key step, but sometimes people forget, right? Because you come to an attorney, we make the trust, and we'll tell you, remember, make sure you transfer everything you want to put in your trust, but then you have to go out and do that, right? So sometimes people will come see us, make the trust, make the documents, and then they'll forget or they'll put it off to transfer the property. And then it kind of becomes pointless because you've made the trust, but if you didn't put your property or transfer your property to the trust, then you're not going to get the benefits of the trust. But hopefully when you see your attorney, they should explain that to you and direct you on as to how to do that. So when you make the trust, you will remain as the trustee and the beneficiary while you're living. If it's a joint trust, when one spouse passes away, typically the other spouse becomes the sole trustee and then the beneficiary. And then after both pass away, then however you have put it in the trust, whoever you've named, typically if you have children, it'll be your children or maybe somebody else, to be your successor trustees and beneficiaries. So trustees are the people that handle and administer the trust, and beneficiaries are the people that receive everything from the trust. So they can be the same or they can be different. You can have somebody else be the trustee to administer it, but have your children be the beneficiaries or vice versa, or it can be the same. For most people who have adult children, they'll choose to make their children their beneficiaries and the trustees, so they can handle it and distribute it according to your wishes after you pass away. So, like I said, we make the trust. It's typically a much longer document, a lot of legal language in there, but it generally speaking, you can get as specific as you want, like this piece of property, that necklace, this goes to that person, that goes to this person, or you can keep it general and just say, this kid gets 25%, that kid gets 25%, whatever it is, however you want, you can make it specific as to each asset, or you can just generally cover your entire estate. So you make that trust, and then the key step then is to transfer your assets to the trust. So for most people, the most important thing is going to be your house, your real estate, any real estate that you own. So for real estate, when my clients come to see me, I will make the deed for them, right? I will make the deed to transfer the house from their individual name into the trust. And so the reason that you want to do that is so that that property is deeded to the trust, and then that deed is going to get recorded with the county that you live in so that it's official. And that means that, when unfortunately everyone will pass away at one point, right? So unfortunately, when that day comes, right, if it's husband and wife, when both of you have passed away, your children or whoever your heirs are, they can then administer that property without having to go to court. So whoever the successor trustee is can handle that, whether they want to sell the property or they want to rent it out, whatever they choose to do at that point, they can handle that. And then if they want to sell, the new successor trustee can sell it and then distribute the proceeds however you specified in the trust. And so it's important to, again, make sure you transfer the property to the trust so that the trustee can do that. Same thing with your bank accounts. So if you want to transfer, if you want those bank accounts to be a part of that trust, then you have to change the name on the account. So if your name is, Joseph and Mary Jacob, if you have a joint bank account, right? Checking account, savings account, Joseph Jacob and Mary Jacob, it's in your individual name. So now if you want that to be as part of your trust, you need to go to the bank and say, hey, I want to change my account to the name of the trust. And so then they would change it to the Joseph and Mary Jacob Trust dated April 26, 2025. Whatever the name of the trust is, they'll change your account to the name of the trust. And then whoever the trustees are can still handle that money. So when you make the trust, you two are the trustees while you're living. And then after you pass away, whoever the successor trustees, typically your children or whoever your relatives are, they can then handle that and then distribute the money out of that account to the beneficiaries of your trust. So if you have investment accounts, if you have other property, another big reason to do these documents ahead of time is especially if you have property in multiple states. So for example, if you have a house that you live here in Chicago, but you also have a house in Florida that you like to go during the winter because everybody wants to get out of here during the winter. If you have two properties in two different states, now if you don't have an estate plan, your kids are going to have to go through this court process in both states because unfortunately you can't probate a Florida house in Illinois, right? So you're going to have to, if you have a house in both states, you're going to have to, your family will have to go through the court process separately in both states. It just doubles the cost and time, right? So, but if you have a trust, you can deed out of state property into your trust and it'll be fine. So, just another reason why, especially if you have property in multiple states, you want to do that. And so then, any other investment accounts, things like that. If it's in your individual name, you want to transfer that over to the trust if you want it to be a part of the trust. Same thing with a business, perhaps. Then another kind of thing to think about too, though, is exactly what falls under your estate that gets probated. It's a kind of a way to talk about it as what are probate assets and what are non-probate assets. So non-probate assets are things that are not going to be covered by your probate case. So for example, that is anything in joint tenancy. So if you have property, let's say your house that you live in, and your husband and wife and you own it together, you're joint tenants. When one person passes away, the other person automatically becomes 100% owner, right? So our same, it's like we're talking Joseph and Mary Jacob, right? They own property that they live in, or any property really, joint tenancy. Joseph passes away, then Mary becomes 100% sole owner because it was joint tenancy. Most people, when you buy a house, if you're married, it's in some form of joint tenancy. The problem then becomes though, so you might think, oh, well, then if it's joint tenancy, I don't need to do anything. Well, unfortunately, what happens if something, God forbid, happens to both of you at the same time, if there's an accident or something? Then joint tenancy isn't going to do anything. It's going to become then a probate asset. Same thing, even if one person passes away first, if the other person doesn't get around to doing it later, meaning creating the estate plan, then again, it'll become a probate asset that will have to go through probate court. And so for that reason, you want to, even when you have joint tenants, you want to make sure that you create that estate planning documents. But for the purposes of probate court, if something is in joint tenancy, which means that the other person is still living, then that's automatically going to go to them and it won't be a part of your estate. Similarly, any accounts with a beneficiary designation. So perhaps maybe you have a like 401k or pension plan where you've named who the beneficiaries are. That's going to go according to whoever you've named as a beneficiary. So നമ്മളത് മാറ്റിയിട്ടില്ലെങ്കിൽ അത് ചേഞ്ച് ചെയ്യല. അപ്പൊ നമുക്ക് ചിലപ്പോൾ നമ്മൾ ഒത്തിരി വർഷം മുമ്പായിരിക്കും ബെനിഫിഷ്യറി ആരാന്ന് വെച്ചത്. Like you first started your job and you only had one child at that time. So you put them as a beneficiary. Now, 20, 30 years later down the line, you're retired, but you never added your second and third child as beneficiaries, right? So you want to always make sure, check when you're the first kind of part of the estate planning process is checking to see who are the beneficiaries I put and do I need to change that for any reason? But any account with the beneficiary that's going to go there, it won't be part of your will or your estate as far as a probate process. Also, insurance policies, life insurance policy, those will always have a beneficiary. So that's going to go to whoever you put as a beneficiary. So same thing, if you took that policy out when you had the first child or something and you put maybe your first child, did you add any subsequent children that you had? Sometimes we forget, we don't think about these things, right? So it's something you want to check on. And other things that don't fall in. So there are certain types of bank accounts like you can put with like a payable on death or transfer on death type of designation. So if you have anything like that, it'll transfer according to how you have it put in that account. So those are the types of things that won't fall under probate, but everything else, typically anything that's not held as a joint tenancy with somebody else, and that doesn't have a beneficiary or transfer on death, payable on death type of designation, that's going to be part of your estate, and that's going to be part of what would have to be probated if you do not have a trust in place and if you haven't transferred that stuff over. Now, let's say, for example, you made a trust, you transferred your house and your bank accounts to that trust, and you did all of that this week. Okay, now, like 4 or 5 years down the line, you decide, okay, we want to move, to a different place. So we're going to sell our house. So we sell the house, and then you go and buy a new property. And then you kind of forget, like, or, maybe you need a mortgage. So the mortgage company is going to make you buy it in your individual name. And now you forget to put that in the trust. Okay. So you bought this new property, it's not in your trust. And then a couple of years later, you both pass away. Well, now that property you have is not in the trust. You have a trust, but that property never made it into the trust. So, even when we make the trust, we will always make a will for you as well. Typically, here in Illinois, sometimes it's called a pour over will, and that's to handle all of the assets that never made it into your trust. So typically, when we do that, we'll make the trust, and then we'll make another will as well, and say all of my property goes to my trust, so that if that property gets left out of the trust, at least it'll go according to how you want it to go. The downside is if that will needs to be used, it will still have to go through the court process. And then, okay, so I see a question about how about the house still having a mortgage? So even if you have a mortgage on your house, you can make the trust, and you can transfer the property into the name of the trust. Now, it does not get rid of the mortgage though, right? I mean, if it did, how great would that be, right? But so even if we have the mortgage, you can transfer the ownership, but you're still liable for the mortgage. The mortgage was recorded, it should have been recorded with the county at the time of purchase. So that property is still going to be subject to the mortgage. So that's like that first priority lien is still going to be there. So you can transfer it, but if there's still a balance on the mortgage company is going to get that amount before you can do anything before your family can do anything with it. So let's say there's still like $100,000 left on the mortgage, but you made the trust, you put the house in the name of the trust, you pass away, and now there's like $75,000 left on the balance of the mortgage. So your kids can go to handle that trust. They can, if they decide they're going to sell the house, they can sell the house, but the bank is still going to get their payoff first, and then whatever is left and balance left over, then your family will get. But you don't have to pay off the mortgage before you can make the trust or transfer the house. So that sometimes people think that, oh, mortgage por onda, so, but you don't have to worry about that. I think, let me look through some of these questions here now. Let's see. So yeah, I think I talked about 401k, bank stock accounts. Most of these will have a beneficiary designation, so you don't have to put it in your trust. But there's always going to be something without it, right? So real estate, personal property, even all the things inside of your house, your jewelry. These are all things that would fall within the asset. And so for those things, bank accounts, right? Standard bank accounts. These are things that would fall outside of the beneficiary designation. So that's what covers that's why you want to have that, to cover all of those other things. Can we designate different persons for medical and financial affairs? Absolutely. 100%. And a lot of times I see that, like people will say, oh, ima na financial കാര്യങ്ങൾ കുറച്ചുകൂടെ അറിയാവുന്ന, പക്ഷെ മോള് medical കാര്യങ്ങൾ കുറച്ചുകൂടെ ചെയ്യുന്ന ഞങ്ങളുടെ കാര്യങ്ങൾ അറിയാവുന്ന. Whatever it might be, you can 100%, they are separate documents, and that's why, because it's never going to be always the same person you want to handle everything, right? Different people, different kids are going to have inclination or kind of a personality suited to different things. And so 100% you can choose different people to handle the separate matters. Rather. Okay, I'm just going to look through some of these questions to see what else. Can you? Okay, so I'm seeing a lot of questions about can you do it online or go through the internet, things like that. Maybe I'm coming with a little bit of a bias, right? Be careful of what you do online, right? You're not legally required to use an attorney to create any of these documents, right? You can always do it yourself, but you just have to make sure that it's going to have the same effect, that and that you're covered, and that it's done properly, right? Because if you do it and it doesn't actually work, it doesn't have the effect that you wanted to have, then it becomes challenging, right? And so most of these online services, they're still going to charge you a decent amount. So you just have to kind of take a look at it. Like a lot of the times you can plug it in, and it's a lot of the details that I talked about, right? So you might think, oh, okay, I went to legalzoom.com and I made my will and I made my trust. Okay, but then did you actually transfer everything to the trust, right? So those are the types of things where sometimes it's more helpful to have the professional helping you out and doing that, so that you can make sure everything is done properly. And a lot of this, again, it varies state to state, the requirements for the will. So for example, in Illinois, you have to have two people witness your will. Certain documents need to be notarized. So for powers of attorney, wills, all these things, the requirements, it depends, right? Depends on the state, whether it has to be notarized, whether it has to be witnessed. And so you want to make sure all of those things are done properly too. So if you go see an attorney in your state, they can make sure that it's done according to the requirements of your state. I see a question about legal protection against creditors. So that's a good question, right? Again, very state to state. I know I keep saying that, but there is some levels of protection, but it doesn't mean that you can go run up 20 credit cards and they're not going to get anything in, then you won't have to, your family won't have to pay that off, right? So when the estate uh, assets are to be distributed, your creditors do have to be paid off, right? So whether that goes to court or not, if you have like we talked about the mortgage or other assets, depending on the situation and depending on the state, there are some protections, like if you get sued, certain things like that, but it's not as protective as people like to think that it is or hope that it is. Just because you put it in a trust doesn't mean that nobody will be able to touch it. It depends on the unique situation and it depends on the state. So I'm not going to go too specific into that. But there can be certain levels of protection, especially when you're coming from like a business liability type of standpoint. But that is something that you have to uh, talk to somebody in your state for specific information in your state. Tax ID. So uh, the need to register the will, that's also, or will or trust, that's also something that varies state to state. In Illinois, we don't have to register a trust. Some states do require that. So again, these are the different kind of reasons that you need to talk to somebody in your state to get information specific to you. But you do, we want to follow the rules in your state. Let's see. I see a question about India. That's a great question. I always tell people, I don't want to speak for every state, but typically in India, it's going to be hard to they're not going to recognize a document that you made here. So the best course of action is if you have property, especially like real estate, land or house, anything like that in India, you want to handle that in India. ഇപ്പോഴത്തെ സിറ്റുവേഷനിൽ നാട്ടിൽ നിന്ന് ഉണ്ടായി വന്ന് ഇവിടെ വന്ന് ഇത്രയും നാളായിട്ട് താമസിക്കുന്നവർക്ക് തന്നെ നാട്ടിൽ പോയി അതൊക്കെ ഹാൻഡിൽ ചെയ്യാൻ വളരെ ബുദ്ധിമുട്ടാണ്. യു നീഡ് സോ മെനി ഡോക്യുമെന്റ്സ്, മുൻ ആധാരം, സോ മെനി തിങ്സ്. ആൻഡ് നാട്ടിൽ ഉണ്ടായി വളർന്ന ആൾക്കാർക്ക് തന്നെ അത് ഹാൻഡിൽ ചെയ്യാൻ വളരെ ബുദ്ധിമുട്ടാണ്. സോ your kids that were born and raised here, they're never going to do it. They're never going to be able to handle it properly. Even if they try, most of them will probably give up. So I always tell everybody the best thing you can do is take care of that while you're able. Either sell it or, whatever you can do. It's hard enough for you to do it. It's going to be so much harder for your kids to do it and navigate that system there. So, either donate it or sell it if you can. I know a lot of people have houses that they go to every year. So you have to make a choice. At some point, maybe it makes sense to get rid of that because otherwise it's just going to go to waste, right? It's so hard with the situation there now to transfer that. I mean, I help people all the time. Sometimes, that people passed away and they still have property in India and they come and it's so much paperwork. It's a big headache because if you have 3 kids that are living in the States, now do all of them have to sign and get things notarized and you have to show up there and depending on the mood of whatever officer you are dealing with there, it can become an issue. Then you need this notarized, they need that, they need everybody to come in person. So it's a complication. It's a challenge that most people in our community face. The best thing to do is to handle that separately there. Most times you can, anything that you put in a will here is not going to get recognized in India. So you want to handle your property in India separately. I think I hit most of the issues. Oh, I see a question about nursing home stay. That is a great question. So again, it varies state to state what the rules are. Typically speaking, nursing homes are very expensive, and if you have assets, they're going to require that type of assets to be depleted a lot of time before the state's going to cover a nursing home stay. So that is something that you have to plan for, and that's something that you want to sit with, most likely with the financial planner, to handle that and to discuss that, because you want to make sure that that's done properly. Now, sometimes people think, okay, well, I can just give all my kids my property, and then like, because I won't have to go to a nursing home for at least 10 years. So I'll just give away everything now. And then by the time I have a nursing home, then I don't have anything in my name. That may or may not work, because um, most states have what's called a look back period. So they're going to look at a certain amount of number of years back, and they're going to say, oh, okay, did she have assets? Did she try to get rid of those assets so that she didn't have to pay for the nursing home? So again, that varies, and that's something that you're going to want to talk to a financial planner or advisor about to plan for that. There are a lot of like investment accounts. You can transfer your 401k or your pension plan, or you know, money that you have in a pension or 401k, 403b. You can transfer that to different types of plans that will cover a lot of that, like annuities, things like that, that will, there are different options, right? Depending on your health situation, your age. Those are things that you want to look for. So that's something that you want to talk to a financial planner about, to see like best case scenario, if you need like skilled nursing care in a facility, what's the best way to plan for that and to make sure that that's covered without depleting all of your assets, right? So no simple answer to that, right? If you can't just put it in a trust and then say, oh, I don't have anything. It won't, it's not that simple. But there are certain things that you can do to try and best case scenario that, right? So that you're um, paying the least amount out of pocket as possible. So we're coming to about the hour-long mark. So I hope I covered most of the questions. If there's anything else that okay, I see one more question about gifting the home while you are alive. So that is an option, right? You can gift to your kids while you're still alive. Um, Ups and downs to that. It depends on your state what the threshold will be for the state taxes there. Um, Again, varies state for state, and also varies, it depends on how much you're talking about. But um, most people are going to be under that 14 million, or even if it's lower, even if it's like 7 million or whatever it is for the federal income taxes, most people are under that. Your state is probably going to be a little bit lower. I think in Illinois, I think currently it's around 4 million, or it depends. So it varies, what the state tax level is going to be. So you want to check that. And then you kind of discuss or debate what are the pros and cons of doing that. If they're not going to face tax consequences if you wait until they pass away to do it, is there a reason to do it? Is it for this like nursing home planning that we're talking about? It depends on the scenario. The one, caveat or warning that I give people is that if you do give a gift, right? If you like deed somebody your house, that's it. You can't take it back, right? You can't change your mind. So the upside of doing a living trust or a will is that if for whatever reason you change your mind 3 years down the line or next week or whenever it is, you can always change it, amend it. If you give something away, if you gift the house to one of your kids, you know, you can't take it back, right? They can give it back if they want, but you can't take it back. So that becomes permanent. So one of the upsides to having the trust and will situation is that as circumstances change, you can change what's in the will and what's in the trust. I think I covered most of everything. If there's any other questions.
So Tina, a quick question. What are the biggest mistake people make when they're setting up the will and trust?
I think one of the big ones is if they've actually done it, is they forget to transfer the assets to the trust.
Okay.
So people, go, they pay the attorney, they make the documents, they bring the binder home and then put it on the shelf, and then they forget, oh, they didn't go to the bank, they didn't go to, whatever it is and transfer the assets. So then now you've taken the time and spent the money to create the trust, but you haven't transferred the assets to the trust.
Okay, great. I have a couple more questions for you. What happens if I move to another state and what do we need to redo the will and trust at that point with that state?
Great question. So trusts typically, it'll vary, but most likely not, right? Because that's the trust, you can have property from other states. There might be requirements as far as registering the trust. So you might have to make like an amendment. You might not, you shouldn't have to redo the whole thing. If it is a will, if for some reason your will doesn't meet the requirements of that state, you might have to redo it. And it's always a good idea, like once you make these documents, to every few years take a look and see if there's any need to update it. Is there anything that I forgot to transfer at that time? A lot of times maybe you made your will and made a estate plan when your kids were young. You did the responsible thing while they were young, and now your kids are in their 20s, 30s, they're adults, their own lives. Okay, well, they don't need Mayor Sandy to be their guardian anymore, right? And so, you want to make sure that you change it so that now your adult children are the ones that are responsible for handling that, right? So whoever, whatever it is, you want to always make sure you update. It's not something that you can do one time, if you did it earlier on. Maybe it is, maybe it depends on when you do it, but um different scenarios, like you said, if you've moved to a different state, it might require some changing and updating when those changes occur.
Okay, great. I just have one more last question for myself. What happens if the trustee or the executor is unavailable or willing to serve when the time comes?
Okay, great question. So that's why we have backups, right? So when we do, at least we usually put at least three people, right? So we'll have the main trustee or executor, and then if they've passed away or if they're unable or unwilling, then you have what's called a successor trustee, and you can list 20 people if you want, right? However many you want as backups. So if the first or second people are not able to or unwilling, you have somebody else. I mean, it's possible, let's say you put three or four people and none of them can do it, then it would be up to a court basically who's gonna do that.
Okay, so basically it goes back to the court if nobody's available.
Yeah.
All right, perfect. I see there's one more question. Somebody typed it in. Let's see. Advice on how can hire an attorney to make a trust.
I always say best thing to do is talk to people who have done it, right? Talk to your friends, family members, coworkers, that have done it. Ask them about their experience. Did they like who they worked with? Now we live in the age of Google where everybody has reviews online and stuff. So, look up and you can see what different people's experiences are, and ask around. Word of mouth. I always tell people word of mouth is the best referral. So that's the best thing you can do for me is, if you thought that your experience with me was good, tell somebody else. So I would say that's the best. And then if you have an accountant or CPA that does your taxes, or a financial advisor or planner, or the real estate agent that purchased your house, they could probably hook you up with somebody to connect you to somebody that they've used or that their other clients use, that they're that knows, has a good reputation for this kind of stuff. That's also a good source if you're looking for somebody to hire.
Thank you. Does anybody else have any questions? You're more than welcome to ask at this point.
I had asked a question.
Yeah.
My name is Tommy Joseph. I'm speaking from Washington, D.C. And I have a question to the speaker. This is about starting a trust. Now, if I have only a bank account and 401k, do I have to start a trust, or there is something else?
So that's a good question. So if everything that you have is on a like a designation, you have a beneficiary designation, you might not need it. It depends, right? So you have to just make sure, like, your bank accounts, do they all have a beneficiary designation? And make sure, like, all the accounts, right? If it's not just one account, is there like a payable or transfer on death designation? And so if that's all you have, there's no real estate involved, you might not need a trust. So yeah, it depends on the situation and again on the state. I can't speak specifically to Washington, but if if everything you have is covered by a beneficiary designation, you might not need a trust.
Okay, thank you.
Mhm.
And now one more thing. Do you have the recording of this speech? Because I was not able to join earlier.
Yes, we do. We will post
Oh,
it. Yes.
okay, thanks.
Tina, looks like there's one more question. It says, can you explain more detail about trust versus will?
Yeah. So again, the trust is typically what we do to avoid the probate or the court process. So if you have a will, it has to be presented and filed in court after you pass away, and it becomes then publicly available. Everybody can see it, and that court process and is timely. It takes time and it's costly. So to avoid that is why you also make the trust, so that you can not have to file that will in court. When you make the trust, you will still make the will as a backup. So in case you forget to put some property into the trust, you make that will, and then usually it'll be like a pour over will, and you say, I give all my assets to my trust. So then that will will still have to be taken to court to be probated. But if you have the trust and you put everything in the trust and everything else has a beneficiary designation, then then your family doesn't have to use that will. They don't have to take the will to court because there's no need. But the trust and the will, they operate the same in that both will say, I want my property to go to, Annie, Bobby, and Charlie, whatever, whoever it is. And how you want the property divided and distributed, you can put in both the trust and the will, but the trust is independent. It doesn't require the court approval and the court probate process. The will does.
Yeah. Somebody asked for your email address. We will share that out when we send out the email. And there's one more question. How much be an average probate fees?
That it varies, right? So I will say it typically, so for most people that I see, average middle class, upper middle class family, if you're talking about real estate, maybe you have a house, maybe a business, something like that. Simple estate plan without any major complications, it's going to run in the $2,000 to $2,500 range for the full package. That's with powers of attorney, for healthcare, property, both wills. This is for a husband and wife, so joint trust, 2 wills, 2 healthcare powers of attorney, 2 property powers of attorney. So it's 7 document package in that range. You'll see a wide range. You could call up an attorney that maybe works like a mile away from me, and they're going to charge a lot more. It just kind of depends. If your estate is more complicated, if you have a lot of complex businesses or different things like that, then it's going to be more time consuming. It will probably cost more. It's certainly probably going to cost more in California. Things are just more expensive there. So it just kind of depends on where you live and the extent of your assets. But I would say for most people, this is an average 2 to, like 2,500, I would say it was like an average.
I have a question. Hi, I have a question. How much is the average cost of creating a trust?
So yeah, so that's what I was just talking about. I would say like 2,500 for the full package.
Oh, I thought it's for the probate.
No, that's to create the estate planning process. To go through
Oh,
probate
okay.
is much more, most likely, because you're talking
Oh,
about
okay.
hiring an attorney, and that can take several months, up maybe a year, maybe more. That can cost your family a lot more.
And if I have a will and still the probate will be the same cost, or I have already a will and then still the probate will be the same cost, right?
Yeah, yes and no, because it depends on how complicated it becomes. If there's like all these people fighting and the court case gets dragged out, then the
Okay.
longer it goes, the more it's going to cost. But I mean, whether you have a will or not, if there's no complications, it'll probably be the same.
Okay. Thank you. Thank you
Mhm.
so much.
Tina, I have another question. Are you willing to do trusts for out-of-state people?
No, I can't. I'm only licensed in Illinois. I can only prepare documents for people who reside in Illinois. Unfortunately, it's, state by state licensing. I would get slapped with the unauthorized practice of law in your state. So I can't. I'm only licensed and can only do anything in Illinois.
I have a question. Can you take license into other states so that you can help others too? Because the financial advisors do that, right?
Yeah, they can do that. It's a lot more complicated for us attorneys. A lot of states I
Okay.
would have to write a new bar exam. I would have to pay a
Oh,
lot more money. Then they have to do background checks, so it's
okay,
not that
okay,
easy.
okay.
All right. Any other questions? Anybody else have any other questions? No. I know that we have a couple of financial advisors throughout our community. I know we have one in Houston. Jomas is one. So if we have their information, we can definitely share that with the community and send out while we send out the, closing email for this session. So Tina, anything else you needed?
Yes, I am one of the financial advisor. I will post my email into this chat box.
Okay. Yeah, if you have a flyer list, send it to us. We can also post it up.
Sure, sure.
Yeah.
Thank you.
If anybody else in this call also does that, please send your information over to us and then we can definitely publish that for you guys too. So, okay. Well, thank you all for attending our Will and Test seminar. We hope that you found this session valuable for your planning the future. Special thanks to Tina. We really appreciate your time helping us guide through this very important topics that we all need to learn and deep dive into. For the convenience, and a lot of people are asking, are we going to post this we will post it in the YouTube channel shortly so everybody can access it. So if you still need any questions or if you have any advice that you need, I know Tina is not able to do it outside of state, but if you need her guidance on anything or questions that you may have, please do reach out to us or Tina. We will publish her information as well with her permission, of course. Again, thank you all for joining this important conversation. We are thinking about continuing this conversation, go to the next topic. So you will start seeing more seminar on this financial side of that a lot of us don't know about. So more sessions are coming. So thank you so much, Tina, and everyone for joining us today. So enjoy the rest of the weekend. Thank you.
Thank you so much, and thank you
Thank
to
you.
KCWFNA for organizing this. I think it's helpful for people. So thank you so much to all of you guys for your hard work.
Thank you so much.
Thank you.